Hey, welcome to Employment Law Show. It's John Scholes and Lior Samfiru once again, filling your brain with good employment law knowledge. You want to reach out throughout the show. We always have the stuff coming up at the bottom of the screen, but I'll give it to you. 1-855-821-5900, help@employmentlawyer.ca. Lior, coming up on the show today, amongst all the things, terminationquestions.com. We'll get to some phone calls from our radio show as well. Working from home, what you need to know. Strong internet. That's what you need to know, strong internet, and watch what's on the webcam behind you. But there's other stuff as well, so we'll get to that here in just a bit, pal. But we always start the show with the week that was. What's been going on with you?
I have strong internet, so I'm okay. But well, I'm always grateful to have this opportunity to speak about employment law. So welcome to the show. If this is the first time you've watched us on TV, well, we're here to talk about workplace rights. We're here to inform you and educate you about what you need to know. Workplace rights are even more important than ever right now because many people, most people's even jobs have been impacted either through a temporary layoff or being let go completely. Maybe because your job has changed, your hours have changed. Maybe you're one of these people sitting at home waiting to be called back to work. Well, we're going to talk about all these things we do every week, and we provide answers and solutions and explain to you what the law says and what the law does. But if we don't touch on your situation, if you still want to ask questions specific to your matter, well, as soon as the camera is off here and I'm off this chair, I'm going back to my office. I'm going to be working and helping people. So reach out to me. We'll give you contact information throughout the show so we can have that chat. Don't be bashful. I'm always happy to help talk and see what the law can do for you. Well, to get us started here, John, for years and years, I've been coming on TV talking about severance packages, and I've been talking about why severance packages are not adequate and what you need to do about it, and we'll talk about that more on this show as usual. But I had a case that came across my desk this week that I just had to bring up on the show. So this particular gentleman that I spoke with was working for the company for 20 years. Now, he was let go. And his compensation, he had a base salary of about $40,000, but he also had commissions and bonuses. Together, he made about $100,000 a year. He was let go, and the company offered him 10 weeks of just base salary. I did some quick math. That was about $6,000 and change. All right, so $6,000 they offered him. Nonsense, ridiculous, terrible. In fact, what he was owed is 24 months' pay, but he was owed 24 months based on his total compensation, which is $100,000. So 24 months at $100,000 is $200,000. So the difference between what he was offered, $6,000, and what he's owed, $200,000, is $194,000. It literally took my breath away to see something that was so obvious and so bad that a company could think they could get away with paying someone $190-something thousand less than what they actually owe the person. Now remember, 90% of the time and 90% of the cases, when you are let go, the offer that the company is making you is significantly less than what you're owed. It may not be $194,000 less than what you're owed, but it may be $20,000, $30,000, or $50,000 less. Well, if that's the case, that's still money that you're owed. So make the call. Let's talk about your severance package. And the other thing, of course, I wanted to remind everyone through this story is that your severance includes all components of your compensation. It's not just your base salary. It's your salary, your commission, your benefits, your bonuses, your car allowance, your pension. You name it, all has to be included as part of your compensation, as part of your severance. And if the company says, no, we're not going to account for bonus, we're not going to account for commissions, we're not going to continue your benefits as long as we should. Again, that's a wrongful dismissal. That's improper. That's illegal. So you may not be $194,000. You may not be owed that much. You may be owed somewhat less, but I assure you that it's still enough for you to pursue what's legally yours. So if you're in that situation, let's talk.
For sure, it's worth reaching out in that regard for yourself as well. 1-855-821-5900. You can always use pocketemploymentlawyer.ca as well. If you go to employmentlawyer.ca, that's where you will catch links to our radio show. We play the phone calls from the show that people call in and have for years on the TV show here. So we'll get to our first call for this program, Lior, right now.
I'm 63. I've worked for the company for 22 years. When they had a shutdown for the CERB thing, I just took the CERB. They called me back 3 weeks ago. In the second week, they asked me to transfer from day shift, which I've been on for a long time, to evenings. Now, I understand that's a constructive dismissal, but I want to know how to pull the trigger on it right. Do I tell them before I actually have to do it, which is next Wednesday, or do I just not show up?
Very common, right? Very common with people
Very common.
back to work, changes to the workplace.
Absolutely. I've been seeing this consistently. So let's start with the obvious thing, and he's absolutely right that if he's working day shifts and now the company says come back but to night shifts, no, that's a big change. That's a huge change. So clearly that would be a constructive dismissal. Again, a constructive dismissal is a situation where the company changes the terms of employment and you choose to treat that as a termination and get severance. Now he's asking, well, how do I go about doing that? How do I trigger that? Well, the best way to do that in this situation is to simply say to your employer, no, employer, I don't agree. I'm happy to come back and work my day shift, but no, I'm not agreeing to change in my shift. Once he does that, the company has a couple of options. Either they say, okay, back off, they let him keep the day shift, no problem. Or the company may say, well, too bad, we're going to terminate you because you refused. Again, they are allowed to do that, but they have to pay severance. That's not a resignation. That's not misconduct. That is a termination with severance. And for this person, it's going to be significant. Or the third option is they say, well, you're starting Monday. Too bad. In that situation, that is a constructive dismissal. So I would tell the company, first of all, no, I'm not agreeing. I want to keep my job the way it was. You can say that. Sometimes just by saying that, the problem gets resolved. Sometimes by you standing up for your rights, the company may back down and allow you to continue the way you were. If that doesn't work, then it is a constructive dismissal and you're owed severance. Now, to complete the picture for this person, let's take his information and let's put that into pocketemploymentlawyer.ca so that we can see how much severance he is actually owed. All right, so let's go to pocketemploymentlawyer.ca and let's have some fun with it. So, let's assume he is in a general labor type of a position. We know he's in his 60s. He's been there for 22 years. So if he, in fact, has been constructively dismissed, or if, in fact, he's dismissed regularly, he'd be owed anywhere from 20 to 24 months' pay. 20 to 24 months' pay, that's a significant amount, more than enough to make it worthwhile for you to stand up for your rights. And you can find out yourself. You can find out, by the way, if your matter is a constructive dismissal, because on pocketemploymentlawyer.ca, we have a tool that allows you to find out, is this really a constructive dismissal? And also, of course, also to actually calculate your severance. So always check out pocketemploymentlawyer.ca.
What would be the pitfall if you said, you know what, you guys have been good to me. I want to be a company soldier. Okay, I'll try the nights.
Well, there's two big pitfalls. Number one is he now is stuck in that role forever, potentially. If they don't bring him back to days, he now works nights, and if he doesn't like it, he resigns because he accepted it. So that's pitfall number one. Pitfall number two is by allowing that change, he's now potentially allowing them to make other changes. So next time they may want to change him to a different shift altogether, or maybe even change his hours. Well, if they do that, because he allowed this first change to happen, he now may be giving them the right to do those other changes. It opens the door and creates a very uncertain situation for the employee. So be very weary about accepting changes to the terms of your employment.
Another resource for you to use anytime to reach out, ask questions for Lior and the team is terminationquestions.com. We'll get to the first one for today, Lior. This comes from our pal Maggie. Maggie writes in, says, I've been harassed daily for the past 6 months by our bank's new branch manager. Not too long after the abuse began, I started experiencing panic attacks. I informed HR, but they're not taking it seriously. I'm now on short-term disability and worried that I will be fired before my return. What are my rights?
Now, this really is something that I would love not to have to come on TV and talk about, because to me it seems so obvious what needs to happen here. And I've seen it so many times when someone is being mistreated in the workplace. They're being bullied, they're being harassed, they're working in a toxic work environment, and it impacts their health. They end up going on a medical leave, and it impacts their family life. It's a bad situation. Now, it seems like Maggie did the right thing, which is she told HR, she told her employer, here's what's happened. I'm being harassed, I'm being mistreated, please do something about it. The reason that's the right thing is because her employer has a legal obligation to take it seriously, to investigate, and then to take whatever measures are necessary to fix the problem. Well, it sounds like Maggie's employer decided differently. And no, they're not taking it seriously, they're not looking into it, they're not doing anything to help her. So Maggie, you shouldn't have to continue working in that environment, because even if you're not let go, coming back, you're going to come back to the same environment, and that's going to impact your health even more. Not a good situation. we're now in a position to treat that as a constructive dismissal. We talked about constructive dismissal before. Another type of constructive dismissal is a situation where the company makes it difficult to continue working by either harassing you or allowing the harassment to happen. If you've been bullied or harassed, you can treat that as a termination. The law says you don't have to continue working in that environment. We can get you out of there with compensation. To me, for Maggie, that would be the right thing to do rather than go back to that type of an environment. Let's treat that as a termination. Let's get you severance. Potentially, there could be also human rights damages that she's owed. So that's the better approach. Remember, for Maggie and for anyone else, you do have a right to work in a harassment-free work environment.
Let's take a short pause, pal. Coming up, working from home, what you need to know. That is on the way. In the meantime, 1-855-821-5900, the number to reach out, and help@employmentlawyer.ca.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Employment Law Show. John Scholes, of course, Lior Samfiru. You want to reach out, 1-855-821-5900, and email us help@employmentlawyer.ca. And it's like having a pocket employment, well, it is like having a lawyer with you at all times. Pocketemploymentlawyer.ca. Very robust website. Included in that is the severance pay calculator, which by now I'm sure you're familiar with. Working from home, what you need to know, Lior, this is affecting literally thousands of people across this country. A lot of people are doing it. Some may not go back, but there's certain things you should be aware of if you're doing that, because a lot of us just kind of breezed into it and didn't think otherwise. First one is this, pal. Let me question this for me. Can my employer pay me less if I work from home? And I can see why employers would try to do that, right?
Well, certainly. I've heard employers say, well, you're not going to have the same expenses if you work from home. You're not going to be paying public transportation and parking and gas, and you're not going to necessarily pay for lunches. So you're saving money. So we should be able to reduce your pay to account for that. It doesn't work that way. The answer here is very simple. No, your employer cannot reduce your pay if you work from home. No more than they can reduce it otherwise. If they reduce your pay, that's illegal. Regardless of the savings, if you even have savings by working from home, that's between you and the savings, that's between you and your accountant, frankly. It's nothing to do with the company. So as a general rule, the company does not have a right to reduce your pay. Now, from a legal standpoint, usually you can do something about a reduction if the reduction is more than 10%. If the reduction is less than 10%, an employer is often allowed to get away with it. But the general rule is no, they cannot simply decide to reduce your pay only because you're working from home.
Can my employer punish me if I need to take care of my kids while I'm off and working from home? Not off, but while I'm working from home.
Right, and this has become a reality now for many parents. You're working from home, but your kids may be home. Either they're homeschooled right now or they're off school. Their school may be closed. Maybe they're in school part-time, or maybe they're not even at school age anymore and there's no daycares or babysitting. So if you actually have legitimate family care and child care responsibilities, an employer does have to accommodate those. An employer has to be respectful of that and understand that you may have these responsibilities. Now, that doesn't mean that you get a get-out-of-work-free ticket. It doesn't mean that just because you're working from home, you're not expected to do work. No, you still are expected to do work. But if there are times where you may need some accommodation because you can't be available all the time, you may need to take breaks to make sure your kids are okay. Yes, the company is expected to accommodate that. You cannot be penalized because you have children. You cannot be penalized because you have legitimate child care obligations. So if the only way you can provide child care is by being physically with your child, but you can still do your work despite that, that is the appropriate remedy. That is what the company is expected to do. Now, if you cannot do your work at the same time, you have to be there with the child, then the company may be required to give you unpaid time off, not let you go, but to give you that time off. But if you can do the work, if you can meet childcare responsibilities, that's what the company needs to allow to happen.
Discussing the topic of working from home, what you need to know. By the way, anything's confusing for you, just reach out, 1-855-821-5900. Help at employmentlawyer.ca. Next one is this, Lior. If I'm being harassed by a coworker, even though I'm not in the workplace, is it impossible for me to do anything about it?
So keep in mind, you are in the workplace if you're working from home. That computer, that workplace that you're sitting in, it's still your workplace, and you still are allowed to work in a harassment-free work environment. We talked about workplace harassment a few minutes ago. The same rules apply to working from home. You may well be harassed, mistreated, or bullied by someone, even if you're not physically in the same room with them. That can happen over phone, over email, etc. And if that's what happens, that's inappropriate. The first thing you should always do is let someone in authority know what's happening. The owner, the boss, HR, let them know what's happening. Tell them that you're being mistreated and give them that opportunity to fix that problem, because they have that obligation. Don't assume that just because you're working from home, there's nothing that can be done. There absolutely is something that can be done, and working from home doesn't change that. If you've tried to do that and there was no response, or maybe there's no one to talk to, it's a small company, or the owner of the company is the one harassing you, then we can still treat that potentially as a constructive dismissal. Same rules apply to working from home. You still have a right when you log into the computer and you pick up the phone to do your job, not to be harassed, not to be bullied, to be treated with respect. And if that's not the case, you have recourse, and I'm always happy to talk to you about it.
You know, this next one's an interesting one, and I know you've been asked this countless times as well, and someone's thinking, you know, I've been home, Lior, working from home because of COVID for quite some time, maybe for months at this point. Can my employer at this point force me to come back to the office if the office opens up again?
So if you've been working from home because of COVID-19, and if the company wants you to go back, generally speaking, yes, they have a right to require you to go back. Now, that assumes, of course, that the company is meeting all the health requirements in terms of physical distancing, masks wearing, limiting number of people in the workplace. As long as they meet those criteria and those requirements, then they can require you to come back to the office. They can say, well, you've been working from home, but now we need you back. Now, there are exceptions to this. One exception may be a situation where, for health reasons, your doctor feels you need to be off work. So if your doctor gives you a note that says, for health reasons, this person cannot at this point come back to the office, if you're able to do your work from home, then the company should allow that to continue, should allow you to continue working from home so that you can abide by what your doctor says. Another situation may be the childcare obligations that we touched on. If you have children now that are at home because there's no school, or school is only part-time, and you have to care for them, you're their parent, there's no one else, then your employer has to accommodate that and cannot require you to come back to work. So remember that. Generally speaking, though, the rule is this: even though you've been working from home successfully and productively, your employer can still require you to come back to work unless there's childcare obligations or a medical issue. And if you refuse to go back, you may consider yourself to have, or the company may consider you, I should say, to have resigned. You would lose your job, potentially any benefits as well. So let's be smart about it. If you're not sure if you should go back and what your rights are, before you say no to your employer, frankly, before you say yes to your employer, let's have a talk.
You know, it's funny you slipped that word productivity in there, which is the last question, really. And most people I know have actually been a lot more productive since they've been home, you know, despite what you may think. But that's a good question. Can my employer let me go, fire me for cause even, if they think I've been less productive at home?
So keep in mind, just because you're working from home, your employer still has the right to expect that you do your work. Sure. Your employer still has a right to expect that you do your work well and productively, and that while you're working and being paid, you're doing your job. Now, there are situations that, because of the limits of working from home, you may not be as productive. You may not be able to do your job as well or as quickly as you would have if you were in the office. If that's the case, certainly you cannot be punished for not being as productive, because it's out of your control. And if your employer does warn you or speak to you about your productivity, make sure that they know that your productivity is impacted by the fact that you're working remotely. Now, it's always difficult to terminate someone for cause, for bad productivity, or for not doing a good job. It's very difficult. The company almost would have to show that you're making a point not to work hard. Unless that's the case, you can almost never be let go for cause. You can be let go without cause or with severance, but as long as severance is paid, yeah, that's okay. What I don't want to have happen is I don't want you to be simply silent if your employer says your productivity has gone down. Make sure that they know why. Make sure you put that in writing, because you don't want to make it easier for the company to even contemplate letting you go for cause.
Employmentlawyer.ca, that is the website you want to go to catch the radio shows. Find a station near you where you can tune in every week with Lior and I doing that. From the radio show, we get another phone call right now. Lior, phone call number 2 for today.
Question I have is regards to non-compete clause in an employment contract. Are they legal and enforceable? If they're going to pay, for example, like 6 months worth of severance, but the non-compete clause is for a year, so they're essentially going to pay for 6 months of salary, but then tell you for a year you cannot work in a similar business.
It's a great question.
It is a great question, and it's something really employees, frankly, an employer should be aware of. So what our courts have said over the years is that we don't like non-competition obligations. We don't like terms that prevent people from earning a living, because we all have a right to earn a living. So if you sign a contract that prevents you from earning a living or makes it more difficult, we're not going to enforce it. Because of that, in most cases, non-competition terms are only enforceable for senior executives, sometimes what we call fiduciaries, people that are in a very senior and sensitive position with the organization, people that if they left and worked somewhere else, it would really damage and hurt their former employer. That is a very small group of people. So because of that, for most people, a non-competition obligation is not enforceable, even if you sign something that says you're not going to work somewhere for a year or 2 years. But it's not as simple as that. So I told you, yeah, you're very likely not, or the non-competition obligation you signed is very likely not enforceable. But ask yourself this: what would happen if your employer tried to enforce it? Well, I'll tell you, if they try to enforce it, they would take legal action against you and ultimately make your life very miserable. They would likely lose at some point. But in the meantime, it's going to cost you a lot of money to fight this. It's going to be a very bad experience. So the bottom line is this: if you sign a non-competition obligation, you have to be prepared to live with it. Because it's not about is it enforceable, it's about whether the company will try to enforce it. Best advice is if you're going to leave a company and you want to work for a competitor, despite signing a non-competition obligation, speak to your employer. Have a good conversation. Tell them, I'm not going to steal your clients. I'm not going to hurt you. I just want to work somewhere else. Most employers are going to be reasonable. If they're not, then they say, too bad, you're not allowed to look at the contract that you signed. If you decide to go work for the competitor, there's a risk there. Make sure that the new company understands the risk, because they may be involved. It's not enforceable in most cases, but the company may well try to enforce it.
Coming up, so you have not been called back after a temporary layoff. We will tackle that after a short break, so stand by for that. 1-855-821-5900, the number to reach out, and help@employmentlawyer.ca as well.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do you do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Employment Law Show. A few minutes to go here. By the way, reaching out anytime. Much more information can be had when we're not doing this show or the radio show. PocketEmploymentLawyer.ca, absolutely free and anonymous. But Lior, want to bounce over with our remaining few minutes here and do phone call number 3 for the day.
because of the COVID, our company shut down. Most of the people have been called back except for like 4 of us, and I haven't heard anything about when I'm going back. Really, I'm at a loss. That's the bottom line. I don't know what the options would be. Do I keep on calling them like every 2 or 3 weeks to find out if business is picking up?
How long have you worked with this company?
10.5 years.
Pretty stressful.
It is stressful, and it's something a lot of employees are having to face these days, certainly more than ever. So let's break this down. She's asking, is it right that they're calling certain people and not others? Well, I'm going to reframe the issue, and that is the layoff itself is not right. Regardless of who they're calling back, the layoff itself is not legal. Remember, I've said this before, a company does not have a right to lay you off temporarily. You can treat that as a termination because they don't have a right to do it. Now, if you accept the layoff, there's no requirement that they call back people based on seniority. They can choose who to call back. But remember, the layoff itself is not legal, which brings me to options. She's asking us, what are my options here? Well, there's really only 2 options. Option number 1 is she waits. She follows up with the company and waits to hear back from them. Depending on where she's calling from, what province, she could be waiting for months, many more months, before the company is required to give her a response. So that's option 1. She waits, she follows up, she keeps her fingers crossed that at some point she'll get a definitive and positive answer. So option 1. Option 2 is very different. Option 2 is that she makes the choice. Rather than wait for the company to make the choice, she makes the choice to treat this as a termination and say, no more. I'm treating it as a termination. I'm going to require you, company, to pay me my severance right now, and I'm going to move on to a different job. That may be better than waiting indefinitely. And by the way, just because you wait indefinitely doesn't mean that you're going to be going back to work. You may be waiting indefinitely just to be told you're terminated, which you could have happen now anyway. So that's the second option. She can make the choice to treat that as a termination. So before we kind of move on from this, let's figure out how much she would actually be owed. Let's take her information, as you can do with yours, and go to pocketemploymentlawyer.ca and see what she's owed. So we know that she's been there for 10.5 years. Let's say she's in a clerical role and in her 50s. She could choose to treat that as a termination. If she does, she'd be owed anywhere from 6 to 9 months' pay. That's what's at stake for her. So with you as well at home, if you've been on a layoff and you want to know what's at stake for me if I treat this layoff as a termination, go to pocketemploymentlawyer.ca. Severance could usually be up to 24 months, so you may be owed that. At least you know what those options are and you know how much you'd be owed.
Going to get one more quick question here, Lior, from terminationquestions.com. From Kurt, he says, last week I returned to the office from a layoff, only to discover that my employer had not taken any steps to make the environment safe from COVID-19. Can I refuse to work until they put proper safety measures in place?
So, fundamental right that you have, all of us have, is to work in a safe work environment. That's true always. It's even more important now during COVID-19. You have to work in a safe work environment. It's your employer's obligation to make it safe. They have to abide by all the laws and all the regulations that are put forward by the health authorities. And if they don't, you don't have to work. So yes, you are allowed to refuse unsafe work. I'm going to go a step further and say you should refuse unsafe work. And if you refuse unsafe work, the company has to either call an inspector to determine whether or not the work is safe, or just fix the problem. But at least something will be done. You could spread the virus if you end up going to a workplace that's unsafe. It's the last thing that we need. You should follow health authorities' directions. The employer should follow those directions. That's the best way to stop this virus, and it's also what the law says should happen.
And again, if you have any discrepancies, just reach out to you, get them in the right direction, right?
Always happy to talk. There's no bad questions. Like I said, I'm done here soon. We're done this show, but I'm not going anywhere. You may have questions. I have the answers, so let's connect.
Reach out, phone call. First place, if you want to start there, 1-855-821-5900 is the way to go. That question came from terminationquestions.com. You can also email help@employmentlawyer.ca. And always have it with you, whether it be on your tablet or your phone or your desktop, pocketemploymentlawyer.ca. Absolutely free, absolutely anonymous, but there is a contact button at the top right as well. Thanks for tuning in, and we'll catch you next time. Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.